You are really dumb. For real.
Hey guys, you might be wondering where my original Jail Me KIRLEW video went, and here's the explanation. On the 11th of April, yesterday, Jamie KIRLEW filed a baseless Digital Millennium Copyright Act, DMCA for short, notice of claimed infringement, alleging that my video was copyright infringing, and as a result, that particular video has been restricted on YouTube. The takedown notification is a claim by the person making it that they own the copyright. However, the problem with such a claim is that my original video did not include any copyrighted material to which Jamie KIRLEW can claim ownership to. Furthermore, fair use of images or any other material do not constitute copyright infringement. I maintain that I own the copyright to these videos that were taken down. Any use of copyrighted material were done so under fair use, and that they did not infringe on any material to which Jamie might own. She filed this claim with a few requirements, including but not limited to a statement that the information in the notification is accurate, and under penalty of perjury, that the complaining party is authorized to act on behalf of the owner of an exclusive right that is allegedly infringed. She was also made aware of the consequences of filing a false claim. Section 107 of the Copyright Act outlines various uses of copyright works which may be considered fair, such as criticism, comment, news reporting, etc. The fact that she did not like what I had to say regarding her seemingly fraudulent transaction on the show, or her cheap look, or her poor dancing are not issues of copyright. It is clear to me that the takedown notification has no merit, therefore I have filed a counter notification contesting the claim. She now has 10 business days to come file a copyright infringement lawsuit against me before the video is reinstated. However, she does not hold any copyrights to the material in question, and lacks standing to assert that my use of any of the content is a violation of any of the owner's rights. Section 512F provides that, quote, any person who knowingly materially misrepresents under this section that material or activity is infringing shall be liable for any damage, including costs and attorney's fees, incurred by the alleged infringer. What this section is saying is that anyone who has had their videos falsely taken down has the option to sue whoever is behind the claim. Additionally, by filing a false notice of claimed infringement under penalty of perjury, Jamie has set herself up for criminal prosecution. If I were to challenge Jamie in court, she'd most likely feign ignorance or even shift the blame to someone else, like she blamed Be Sensible when she was called out for her couponing fraud. If she decides to feign ignorance, I'll be ready to ask the court for subpoenas to send to YouTube and her ISP, forcing them to give the identifying information proving that she was the one who filed the claim. She may have even used her head for once and used a proxy when filing the claims to make it a bit more difficult to track, but that is doubtful. I'm sure she is probably very proud of herself now for having my video taken down, without any clue to how persistent I can be, and she probably assumed that I would be clueless about the applicable laws, or my rights, and that she'd somehow trump my knowledge simply because she works as a paralegal. She assumed wrong. It is actually laughable that someone like Jamie who works for a firm would be so clueless and would be so arrogant enough to think that she is above the law. I've talked to many people about this, and we've all come to the consensus that you file the DMCAs because you're scrambling and feeling the heat. Maybe next time you'll think twice about filing a false DMCA or abusing coupons.